Yes, Mr Lewin.
Lords, may it please you. I was beginning my submissions, I think, on the sitting balance.
Yes.
And I've said much of what I wanted to say already, I think.
Yes.
In answer to the questions that were raised. The relevant part of my skeleton argument, which is a tab 5 call bundle, is paragraphs 28 onwards, page 48. Which I perhaps begin just briefly with the point that was raised about what the 134,000 sitting balance comprised. And also we have, in response to the questions raised this morning, found the schedule of Mr Forrester's evidence, which shows, in a rather almost convoluted way, that the 134,11872 did not include the 3 disbursements, which the friend seeks now to include. I can show that to your lordships if that would be of assistance.
Do you have copies?
I do, lordship, yes, just to make good on that point, if I may.
Were the Reeses compiled on a cash basis or an accruals basis?
I can just
This schedule is clearly on a receipts basis.
lordship, yes. As far as the income is concerned.
And the deduction of rent received after the 30th, but included in the 1st of October balance, looks as though it's on an accruals basis.
Your lordship has the better of me in terms of...
I'm sorry?
Your lordship has the better of me in terms of characterising. Your lordship, as I understand it, that the rent was simply included in the account as it was received, but since it would have been received after the due date.
Well, if it was included when received, then what's this deduction of rent received?
As explained by Mr Forrester in his evidence. Your lordship, to explain the schedule, if I may, the 148,926 was the retained balance for the Reese, so tab 11 in the bundle. So that was the Reese that for the period the 1st of July to the 30th of September. So that's the prepared on the 12th of November 2014. Lordship, what Mr Forrester did was then look at the rent received after the 30th of September 2014, but included in the above total, and take that away as your lordship sees. And then add back the supplier payments and the three subject disbursements to arrive at a sitting balance that therefore did not include the disbursements having been made. He's added it back to arrive at the sitting balance as at the date of the start of the relevant period. So you might imagine this schedule makes it clear that those disbursements were not included. Which, as I understand, that's common ground. And that was the agreed sitting balance as at trial. Essentially, what one might go further and say is that in itself represented an agreement to reverse the appropriation, but your lordship, that's perhaps going a little bit too far. Just as a matter of consistency, the sitting balance therefore comprised entirely rents and deductions only up until the 1st of October. So it was just rent received up until that date. And your lordship, that then engages the issue.
So, is this right? But if, apart from this schedule, Mr. Lightman is right in saying that the deductions were appropriated in the REISs, this, you say, is an agreement to use my Lord Justice Nugee's phrase, to recharacterise those amounts as being still outstanding.
Well, Your Lordship, what I say is that the Moylan order and the NWA had that effect. But Your Lordship, I could add, as an additional argument, that this agreement, that was the sitting balance, has that effect. Your Lordship, my primary argument must be on the interpretation of the MWA and the Moylan order.
Yeah, I quite follow the argument on the MWA and the Moylan order. In terms of the suggestion that this could itself be an agreement recharacterising, in front of the judge, there was no agreement in relation to the 31,000, the 80,000 or the 50,000. To the contrary, it was Docklock's claim that they should be treated in a different way, as I understand it.
Your Lordship, yes, they were. Yes, Your Lordship is right. They maintained the claim, which was then rejected. So Your Lordship, perhaps I go too far in saying that.
But there was agreement on what the sitting balance was.
I beg your pardon,
There was agreement on what
Yes,
the sitting
indeed.
balance was.
There was, yes. And that represented, as one sees, it's simply rent up until that date. And you have my submissions on the interpretation of the Moylan order and the
Well, that's your main point, so shall we get on to that?
well, Your Lordship, yes. That's it. So can I take you to the order?
Yes.
Your Lordship has that in the full bundle at Divider 16. And Your Lordship, it's paragraphs 18 and 19. And the exceptions under 19. And Your Lordship, importantly, this was part of the global, or represented a global settlement of claims, and what was a hard-fought divorce proceedings that lasted many months. So there were claims either way between the parties. And clause paragraph 18, parties agree, and the introductory recitals, the parties agree that the terms set out in this order are accepted in full and final satisfaction of, and I draw particular attention, Your Lordships, to the words all claims for income. And then there's a further list of referring to capital, all claims in respect of others' pensions, and so forth. And paragraph 19, furthermore, the parties agree that save in respect of the potential claims listed in subparagraphs A, B, and C below, save as otherwise provided elsewhere in this order together with the mutual waiver agreements is intended to be in full and final satisfaction of all and any claims in England and Wales and any other jurisdiction, including for the avoidance of doubt and other claims are mentioned there. The only exceptions to this are the following civil claims in subparagraphs A and B, and the exception at subparagraph C. I think Deputy Master Smith observed that the paragraphs A and B that were referred to in Lord Justice, Mr Justice Moylan's order, he queried earlier whether there was a travelling draft or not. He determined that capital A and capital B became 19A and 19B. So coming to those, 19A, any claim or counterclaim by any of the applicants' companies against Christo Co and or the respondent in respect of any monies received by Christo Co as agent for any of the applicants' companies in respect of the period, and then it sets out the relevant period for which it is asserted the respondent and or Christo Co is not duly accounted to and has not paid over to that company, including in respect of rent. Now, the leading provision is that it must be a claim. It is a claim in respect of monies, and that would be the rent received within, in respect of, and we've all taken that to mean within the relevant period. So the only exception that is created by 19A is in respect of rent received within that relevant period. And then there's the further exception, that if that claim is brought, exception upon the exception, if that claim is brought, then Christo Co, if any claim is brought against it, then Christo Co, if any claim or county over Christo against any of the applicants companies in respect of management fees, so that is the further exception in respect of that period and confined to that period, any claim for management fees. And if we pursue that claim for management fees, then there is to be a set-off for occupation challenge. But my lords, what emerges clearly from that, in my submission, is those are a carve-out, which is the phrase that has been used, from what is otherwise a global waiver of claims in full and final satisfaction. And it is a carve-out solely for the relevant period, beginning on the 1st of October 2014 and ending on the 1st of September 2016. And the mutual waiver agreement, although it varies slightly in point of detail, as we've seen and I understand to be common ground, it reflects exactly that. And I don't seek to say otherwise. That was the decision of Deputy Master Smith, that although there weren't the end dates mentioned in paragraph 2, perhaps we should look at that as well, Your Lordship. Page 271, next slide. And the general waiver on both sides, in respect of claims by companies for the reasons which have been explained already, is found at 1, and in particular 1C, present purposes. British companies hereby agree to and do waive and enter into this agreement in full and final settlement of all and any claims and rights of action, either existing now or which may arise in the future, which any of them has or may have, whether in England, Wales, or in any other jurisdiction, against Chris or any of Chris's companies, arising out of the dealings between them to date. To date, Lordship, say at the date of the order, notwithstanding, of course, that...
I mean, looking at the schedule of properties, it seems to be a fairly mixed bag of commercial and residential properties. If I were to assume, there's no evidence of this, but it's common, that at any rate the commercial tenants paid their rent quarterly in advance, and a payment for the quarter beginning the 24th of June 2016 was received by Christo during the relevant period, does the whole of that payment come into account, or is it apportioned? Well, that may depend on received in respect of the period means.
Yes.
What did happen?
Well, I don't think there was any question of apportionment. I think if payments were received before the relevant period.
So if a quarter's rent was paid on the 24th of June in advance, the whole of it went to Docklock, even though part of it was referable to the period between the 1st of September and the 25th of December.
Your Lordship, that's the way in which the account was run, the underlying account. And Your Lordship, no point was in fact ever taken, no point was argued for those terms at the trial. No one took that issue. And so Your Lordship, I can see the point Your Lordship was making, but it just simply didn't arise on the facts as such.
Do we have any material shedding light on why the relevant period runs from the 1st of October? The judge doesn't say anything in his judgment about
the background to that, of course, the background to that was that the parties had fallen out with the service of the divorce petition in or about October 2014. So that's when the divorce proceedings effectively began. And Your Lordship already knows the end date, although as I think we were actually replaced as the managing agent in December of 2016. But our contract was, a new managing agent was appointed in December. But I think our appointment came to an end in or about October 2016. That explains the start and the finish.
But these dates were not laid down by the judge at any stage. They would negotiate and agreed by the parties, were they? Or?
They were.
Yes.
Yes. Yes.
And then
Yes.
endorsed by the judge when he made the order.
That's as I understand it. Yes. But there have been. Yes, that was the subject of negotiation between the counsel in the family proceedings.
Because all the judge says is, I'm persuaded that it's appropriate to make an exception for rents,
Yes.
which may not have been accounted for.
Yes, and as I understand it at the time, of course, and one sees that from the claim, from the original offence, Christo Co was also claiming management fees, not just for the relevant period, but from outside the relevant period. So the purpose was to try and limit the area of dispute between the parties to the relevant period, and strictly within that period. And that's what I said. Reinforces the point that this was simply allowing, or was to allow the parties only to claim from the 1st of October.
Well, as far as the chronology is concerned, we've got a bit in the judgment. So we can see from paragraph 9 of the judgment on page 65 that the petition was issued on the 4th of June 2014, but not served until the 19th of October. So the 1st of October doesn't tally with either of those.
Not quite, no.
And we can see from paragraph 23 that Christo continued to manage Docklock's property portfolio until about the 23rd of September 2016, which is after the end of the relevant period.
That doesn't tally either.
But that doesn't answer my Lord's question of why was this chosen as the relevant period?
As a matter of negotiation between the parties. I can only infer that. I don't know it as, but Your Lordship, that seems to be how it evolved, I must say.
Yeah.
And I
All right.
see that as a bit controversial. Your Lordship, that's how I'm saying. And one can see in the Senate that they are, well, arbitrary, one might say. They're broadly aligned with those the events to which you just referred to, but not exactly. And that speaks to the fact that it was a carve-out just for that period.
Just before we leave chronology, I mean, I think there are two chronologies in the bundle. There's one at the back of the supplemental bundle from you, I think.
Yes.
And there's one at tab 6 of the core bundle, presumably from Mr. Lightman's side. If I just look at the Mr. Lightman one, for this, first of all, do you take issue with anything in there that you're aware of?
Your Lordship, I don't think there are, I haven't done
an
audit, but I don't think there are, I certainly haven't lighted on any dates that are different.
I mean, not that I really don't think this matters, but I see in terms of the discussion of when you stopped managing the properties, page 55 of the core bundle, we see there it says 1st of September, conclusion of the relevant period. 19th of September, you ceased to manage the portfolio. But then I think I saw, and you mentioned this earlier, that in your chronology, replacement agents were appointed in December.
Yes.
Anyway, so that's how it is.
I did go straight to the chronologies when the point arose to try and see if they shed any light, and that's as much light as they do shed. So,
yeah.
So it is that in some sort of rough way, as a result of negotiation, every word was fought over. I know that for a fact in relation to the mutual waiver agreement, and of course the many months that one sees it took for the court to draw the order speaks to that as well. Lordship, what I say that the appellants are trying to do in this appeal, as they try to allege, is to claim that sitting balance. It's Justice Leach, as he is now, said that that's what in substance they were trying to do. And my submission, that is what they are trying to do. They are taking the 3 disbursements made within the relevant period, and in effect they are trying to reverse them into the sitting balance. That is the only way in which they...
I mean, might it be said that that's really the wrong way round in this sense, that if we look at Mr Justice Moylan's or Lord Justice Moylan's order, exception A says it's possible for you to bring a claim, it's possible for Docklock to bring a claim in respect of monies received after the 1st of October. And that's what they're doing. They're not claiming in respect of any monies received before the 1st of October. But then on the other hand, it's possible for you to assert that money has been duly accounted for or paid over. So on the face of it, Docklock is claiming in respect of rent received after the 1st of October, and the real argument is over what matters you can bring into account on the other side.
Well, I fully understand that point, but that would be so if this wasn't a carve-out. But it is a carve-out. So there is a settlement in respect of sums that have accrued up until the start of the relevant period. And so that's where one arrives at the point that this opening balance, in effect, is zero, because the parties have waived their claims in respect of sums that were received prior to the relevant period.
Yes, I mean, might it be said, well, at the date Mr Lord Justice Moylan makes his order, Docklock is saying, okay, I can't bring any claim in respect of rent received before the 1st of October. As it happens, I didn't have any such claim anyway, but I am entitled to bring a claim in respect of rents received after the 1st of October, and then it's for you to show that there are payments that you made that fall to be taken into account on the other side of the ledger.
Lordship, if the account starts, and that's the premise almost of your Lordship's question, if the account starts on the 1st of October, then in my submission I must be entitled then, in a sense, in the arbitrary, broad justice sense in which Mr Justice Moylan recognised the order might work, I should be entitled to deduct disbursements that are made within that relevant period. So I say that is really how the order has to work, by virtue of being a carve-out from what is otherwise a global settlement of claims. Otherwise you are, in substance, reversing those deductions into the sitting balance, which has been, the claim for which has been necessarily been waived. And that's why Mr Justice Leach said, well, questions of running accounts and the application of Clayton's case simply don't arise because I'm taking an account that begins on the 1st of October. So in terms of Clayton's case, the account is broken at that point, and now we are looking at the income and deductions within the relevant period. Or should I say that was the right interpretation of the order. This is the point I take in my respondent's notice, wasn't referenced in this context by the judge, but I would say that in fact that had effectively also been decided before that by Deputy Master Smith, and that I say is clear from his. If I could take you to that, and I think you now looked at some of the decisions in the supplementary book. Paragraph 30. So this is the judgment on the summary judgment. And the real issue, as you've heard already, for the purposes that he had to dispose of, was whether I was entitled to claim management charges either side of the relevant period. He determined that I wasn't. And in doing so, he says this. We're going to take it up at 36, paragraph 36. The MWA,
36.
which is page 17, divided 2. The MWA must be construed in the light of the judgments of Moylan J and the order. They form part of the matrix of fact, and the MWA and the order cross-refer to each other. Paragraph 19 of the order says that the order together with the MWA is in full and final satisfaction of the claims of the parties and the companies against each other, whilst paragraph 1 of the MWA states that it is subject to the order. They were intended to operate in tandem in order to ensure that all issues between the parties and the companies were dealt with as Moyle and J intended. And the MWA was prepared to, in order to give effect to Moyle and J's judgments. Therefore, the MWA must possibly be construed in a way that's consistent with the orders and judgments. And then this. Terms of the paragraph 19 of the order are clear. Any claim by the defendant for management fees is limited to the period 1st of October 2014 to 1st of September 2016. Any claim by the claimant for rents collected or an occupation charge for 66 Parkway Limited to the same period. It seems clear that there was to be no claims for rents collected, management charges or an occupation charge outside the period. This arrangement is reflected in clauses 1 and 2 of the MWA. Moyle J set out what he was seeking to achieve in his judgment on the 19th of January 2017. The starting point was full and final satisfaction. He concluded that there should be an exception to allow the claimant to pursue its claim for unpaid rent collected by the tenant during the period 1/10/14 to 1/9/16. If he permitted that, he considered it appropriate to permit the defendant to claim to be entitled to deduct a management fee, in which case it would be appropriate to allow the claimant to claim to be entitled to an occupation charge. Those were exceptions he was considering. They were set out in the order, and they were each expressly limited to the period 1st of October 2014 to 1st of September 2016. Limiting the claims to that period was clearly intended to be mutual. I do say this speaks to the intention behind the order, and indeed the intention of the parties who entered the MWA. But I continue. It would be contrary to this scheme, and contrary to what the parties must be taken to have intended, if the defendant were entitled to deduct management fees for a different period. He then deals with my arguments, or not my arguments, but the arguments were advanced on behalf of the defendant, paragraph 39, claiming to set off management charges outside the period, and by relying on paragraph 3 of the mutual waiver. He says this at the end of that paragraph: it cannot have been intended that the parties should be able to recover rents, management charges and occupation charges outside that period by the back door under clause 13, reinforcing the point you cannot recover, neither party can recover rents outside the period, nor for my part management charges. Therefore, the reference to any set up in clause 3 cannot include rents, management fees and an occupation charge outside the period. It should also be noted that, as explained at paragraph 12 of his judgment, paragraph dated 19th of January, Moyle and J envisaged the management fee claim as a set-off. He referred to the defendant being entitled to deduct a management fee if he permitted the claimant to claim rents, and he approved paragraph 19 of the order on that basis. This reinforces the view that there was no intention that the defendant should be able to set off management charges for any wider period. And then this, he adds, paragraph 41. Further, if the defendant were right that clause 3 permits it to set off management charges prior to October 2014, the defendant may have to give credit for rent collected pre-October 2014. It would be extraordinary if the defendant could not only retain for itself rents collected as agent for the claimant, but also charge the claimant fees for collecting those rents and for managing the properties producing those rents. Permitting the defendant to claim pre-October 2014 management would therefore open up areas of dispute which Moyle and J meant to close off and cannot have been intended. So, he's quite clearly, in my submission there, accepting that there could be no claim for rents collected prior to the relevant period.
This is very interesting, but to what extent are the appellants bound by what he says when giving them an interim payment?
I say in my skeleton, if it's not binding, then it's highly persuasive and should have been taken into account by
Do you say it's some form of res judicata or estoppel?
Actually, reflecting, I do think I was perhaps a little coy there. And I do. It does seem to me that this is binding, and it's a decision that has never been appealed because.
But how could they appeal this part of a decision. This is a reason, one of several,
Yes.
for rejecting your argument, or the argument put forward on behalf of the defendant, that a set-off could be asserted in respect of management fees from before 2014. And he's rejected that argument for a number of reasons, one of which is the one you've just read us.
Yes.
At the moment, it seems to me to be difficult for the appellants to have appealed that. At best, they might have, if you had appealed the interim payment, said here was another reason why it should be upheld. And in circumstances where they can't appeal that, are they bound by it in any relevant sense?
Was it, my submission, it does appear to be part of the ratio of the decision that we were not entitled to recover management charges outside of the relevant period. So, to that extent, I do say they were bound by it. I take the point that they couldn't appeal it because the determination was in their favour. But it's absolutely within the compass of the argument that I was, or the decision that I was not entitled to look outside the relevant period.
But you don't go so far as to say there is an issue with estoppel.
Well, it does amount to that, and that's how I put it in my skeleton. They can't approbate and reprobate. They seek to rely on this, of course, in terms of their alternative ground, their ground two. And I say they can't approbate and reprobate by picking parts of the decision, but at the same time rejecting parts of the reasoning. So, Your Lordship, I do say effectively it's estoppel.
My recollection, and we're going into uncharted territory here, or unnavigated territory here, is that my Lord Justice Lewison and I sat on a case some while ago during the pandemic where the scope of issue estoppel was raised, and it was thought in that context to be relevant whether or not a party could appeal.
Your Lordship, I'm sure it is relevant. We are moving into unnavigated territory for the purposes of these proceedings. Perhaps should have done more homework on.
Well, there was a bit of authority on the point, but we did discuss it.
Your Lordship,
Should anybody ever want to look for it, was it called Thomas and Love Productions?
Yes, LUV.
Your Lordship,
Was the name of the band that they were members of.
Your Lordship, I say it's so close to the point that it effectively operates as an estoppel. As I say, I put it in terms of them not approbating and reprobating in relation to this. And I say it should have been taken into account by Mr Justice Leach. He didn't expressly refer to it in this context. But he said elsewhere that he wasn't seeking to depart from Deputy Mr Smith's decision. So I think he had an eye to conforming with the decision that had been made. But I say this very clearly speaks, if it isn't binding and there isn't an issue of estoppel, it very clearly determines the intention.
Well, if it's not binding and there's no issue of estoppel, then we look at it for its merit, on its merits.
On its merits, yes.
I mean, looking at it on its merits, or even if you treat it as binding, the Master wasn't actually deciding this question. He had in mind the bits of Lord Justice Moylan's order that said you can claim in respect of rents for this period, and you can claim for management charge for this period, and you can claim for occupation charge for this period.
Yes.
And none of those is an issue on this appeal.
Well, Your Lordship, to an extent it is put in issue by the appellants seeking to apply the 3 disbursements to rent that had been collected for the period before the relevant period.
Yeah, I probably am begging. On their case, they're not claiming in respect of rent received before the 1st of October.
Yes, that's helpful.
You're not claiming in respect of management charge before the 1st of October. They're not claiming occupation charge or rent before the 1st of October. What we're really concerned with is how far you can make deductions for things you did.
Your Lordship, they're certainly not contentious deductions for VAT, and the fact that I paid them, I actually accounted for the money. One might think that actually if they had been contentious deductions, they wouldn't have been running this point at all.
Well, they're not contentious in the sense that nobody disputes that they were disbursements properly made. The issue is what is the correct accounting treatment.
Well, actually, yes. At the risk of repeating myself, I say the accounting, they were within the relevant period, therefore they were properly.
Yeah, and you say that's what Mr Justice Moylan's order means.
That's what it means. Yes.
Right. Well,
Because
is there much more to be said on this?
Your Lordship, there isn't. I suppose I should say in terms of Clayton's case, that it's not a running account across those dates. That the account is broken.
Yeah.
To use
You say Mr Justice Moylan broke the running account, that the whole process was to start again with a clean slate, and therefore the running balance should be taken as zero.
Yes.
And the sitting balance was, any claim to the sitting balance was waived, and it now belongs beneficially to Christo. So there's no question of fiduciary accounting, that's Christo's money.
Just as, if I may add, not wishing to confuse, at the other end of the relevant period, we attempted to claim credit for money that we had received when we were no longer the managing agent, and Leach said, by the same reasoning, I'm not going to let you recover that, claim credit for the 85,000 that you paid across, as it were, voluntarily. So there were swings and roundabouts there.
I've seen this said in the skeleton. I haven't properly understood the point. So what were you seeking to claim credit for?
Well, after the end of the relevant period, we had accounted, the staff at Christo had accounted for rents received because tenants carried on paying rents to us even though we were no longer appointed, less certain deductions. And we tried to say, well, that we should be entitled to credit for that amount, for the 85,000 we paid across after deductions, after the relevant period. And Justice Leach said, well, you can't do that because that was paid after the relevant period, out of income received after the relevant period. So one has to get one's head around the idea that
I'm not sure I see a parallel exactly. If after the relevant period you are receiving money,
yes,
and out of that money are paying Docklock,
yes,
so that if you took into account what had happened after the relevant period, you'd have to take into account both sides of the equation. Why is that comparable?
well, I was trying to claim credit for that money on the basis that I didn't, which I think the importance of the point is that it shows it wasn't a running account. It was a question of, going back to your Lordship's point, claims within that period. And I couldn't have any claim for that 85,000 because it came outside of the relevant period. It's dealt with at paragraph 70 to 74 of the judgment. In terms of the interpretation of the order and the application or inapplicability of Clayton's case, those are my arguments. I wasn't proposing to go to the authorities so I have no issue with the principle of Clayton's case, but as is already pointed out with reference to the judgment of Lord Herschel in Corrie and the other references which you've seen already, that is not, Clayton's case is not an inviolable rule. It's referred to as the rule of convenience or rule of evidence, and it gives way to the particular circumstances of the case. And I say it must give way to the, in this case, to the terms of the Will and Order and the MWA. Lordship, that brings me, if I may, to ground 2, unless there's any point I haven't covered. Lordship, the staff salaries. My submission there, perhaps I should just turn to my skeleton on that. Your Lordship, it's quite briefly, it does appear to me to reduce to an argument as to how the staff salaries are to be classified. I must say I have struggled with the notion that there's any issue of retrospectivity or however a learned friend puts it in relation to staff salaries. I do not, well, my submission that the argument that he raises turns on whether they were management charges or not. If they were management charges, as Lady Justice Falk observed in giving permission, then they were management charges in respect of management from an earlier period, and they wouldn't. I couldn't claim them within the exception at 19B, but Your Lordship, they were not claimed as management charges. They were claimed as salaries, and I can take you to the pleadings if need be, that the management charges were always claimed as a percentage of the rents that have been collected, or the lettings charges were claimed as a percentage on those transactions. The salaries, as we've seen by reference to the correspondence from the solicitors, was something completely different. They were staff salaries, national insurance contributions, and it included also in the figures car hire charges. So they weren't management charges, and as my Lord Nugee has observed correctly in the judgment, they were awarded in lieu of management charges. That's what the judge repeatedly says in his judgment. So I should just take you to the references for that in the judgment call bundle tab 9 again, and page 100. Your Lordship, it's really from paragraph 90.
103 is a central finding on what the agreement was.
90, I beg your Lordship's pardon. I was at paragraphs 96, 97. So 96, he rejects my case that there had been a wider agreement as to management charges. And then at 97, nevertheless, I am satisfied that by January 2013 that the latest Docklock payer agreed to pay the salaries of Nicholas and Mr Forrester, page 100, paragraph 97, in lieu of management charges. I accept Nicholas's evidence that there was no meeting in which he expressly agreed with Chris that Docklock would pay a reasonable fee for Chris's services. I'm satisfied that he already agreed with Chris that Docklock would pay his and Mr Forrester's salaries in lieu of management charges. Such an agreement could not have taken effect without his agreement, or the agreement of Mr Forrester and Nicholas fully accepted that there was such an arrangement. And the position was that, in fact, Nicholas and Mr Forrester, their employment was transferred across to Docklock, and these charges were in respect of a period when, as explained in the accountant's correspondence, these were in respect of a period when Docklock did not have its own PAYE system, and therefore the salaries continued to be paid by Christo. So they're paid in lieu of management charges. I think that the same point is made at paragraph 103 on page 103, which Your Lordships were taken to. Again, I found the arrangement was the subject of an oral agreement between Chris and Nicholas, and that they agreed that Docklock should assume the liability for the salaries of Nicholas and Mr Forrester in lieu of management. And I think also it's repeated at paragraph 109, subparagraph, which is at page 100, 105, 106. The paragraph begins at 105, and then at little Roman numeral 2, I found that there's a binding contract between Docklock and Christo for payment of salaries in lieu of management fees. But there was no suggestion that this agreement extended to letting or renewal fees. He rejected my wider claim for management fees, although then allowed them under, which included professional fees.
By whom were Nicholas and Mr Forrester employed? They're employees of Docklock.
They had,
Christo.
their employment was transferred across at the time when Christo Co was
So
actually cashed for.
Paragraph 103, the judge finds an agreement that Docklock should assume the liability for the salaries of Nicholas and Mr Forrester. So who would otherwise have been liable to pay those salaries? Is it Christo?
Christo, yes. And the point is that my sufficiently short one, because in lieu of means
Instead of.
in place of. And that is exactly the basis on which they were awarded by the judge, as you've seen at page 110, where he deals with staff salaries as a separate disbursement. On the 30th of January, Mr Forrester paid the sum of 64,127 to Christo on behalf of Docklock. In response to Mr Petrides' letter, the Scotch Schedule of Docklock challenged this payment on the grounds that it was unauthorised and that there was no proper explanation for it. In my judgment, there was no such thing. That challenge, I found that there was a contract between Docklock and Christo for the payment of the two
Sorry,
salaries.
I've lost you. Where are you?
Page 110.
Page 110.
It's the section dealing with staff
Yes, I see.
salaries.
Yep.
And I haven't taken you to it, but in the Scotch Schedule, I only refer to paragraph 19A as the basis of claim. Mr Missy also challenged this. I was reading from the first paragraph 120. In my judgment, there was no substance in the challenge. I found that there was a contract between Docklock and Christo for payment of the two salaries. It's clear from Mr Petrides' letter and his subsequent reconciliation, this payment was made pursuant to this contract. Mr Missy also challenged this payment on the basis of timing and that it related to a liability which accrued during the financial year 2012. Again, I reject that submission. It was an outstanding contractual liability which Docklock was liable to Christo, in my judgment, was entitled to use the funds which is held on account to discharge that liability. So it was allowed as a disbursement in the ordinary course.
But how does that square with the waiver of all claims both ways for pre-2014 matters?
Well, it squares with the fact that disbursements in the ordinary course of business were allowed for the whole of the relevant period, and there was never any issue about that. Indeed, there was some £600,000, £700,000 worth of disbursements that were not challenged. What you see in the Scotch Schedule are the list of disbursements that were challenged. So there was always a class of payment which were the disbursements in the ordinary course of business during the relevant period.
So the payment was made during the relevant period, but related to a period before the way in which the judge expresses himself in paragraph 121 is that there was an outstanding contractual liability, and that seems to accept as a fact that the liability had accrued during the pre-relevant period, accrued during the year ended 31st March 2012.
Lordship, yes, it's the same as one might say the VAT payment, which is the liability for that would have accrued prior to the start of the relevant period. But as I say, there was always a category under 19A of disbursements in the ordinary course of business, and that's the basis upon which I claimed this deduction, and the basis on which it was allowed. There's no appeal from the facts of the matter, if you will.
Well, there's an appeal in relation to this. I mean, leave aside the fact that there's no appeal in relation to other ones.
Well,
there's an appeal in relation to this one, and the appeal, as I understand it, is on the basis that if you're right on ground one, the premise of your argument of ground one is that the effect of the order and the MWIA is to reset the amounts due to each other to zero as at 1st of October 2014. So you start again in October 2014. Why does that not apply to a contractual liability owed the other way from Docklock to Christo as at 1st of October 2014? Why is that not also reset to zero on the basis of the full and final settlement of everything up to that date? What's the distinction between the two? I haven't understood that.
Lordship, apart from drawing attention to the fact that it's not the way it's been argued, nor is that
Maybe.
the ground upon which this appeal is brought. The appeal is brought on the basis of
But I think your point is that this is a cash account, not an accruals account.
Your Lordship,
And
yes,
therefore what
in
matters is
effect.
when rent was received
Yes.
and when
So-
disbursements were made.
Your Lordship, yes.
That's
In
why
relation-
you say you can deduct the VAT, because although the liability to pay the VAT may well have accrued before the relevant period, in fact it probably did,
It's done on
you
it.
didn't pay it
Yes.
until the relevant period had begun.
Your Lordship, yes. It's simply a disbursement, which is what Mr Justice Leach decided.
And I think you will also say that your calculation of the sitting balance, which ultimately was accepted as correct, is likewise done on a cash basis, not an accruals basis.
Your Lordship, yes. I think that's the simple arithmetic of it. Yes. Simple approach that's taken.
Yeah.
So that's the. I mean, I accept the further point that was raised that the staff salaries are then included in the table in the management account and form the basis of some of the argument in relation to the supplementary point as to whether there should be a further management charge after the salaries ceased to be paid, as a matter of fact. But Your Lordship, and to that extent they were characterised at various points, or each side tried to characterise them as management charges or not. But Your Lordship, ultimately, they've been treated as staff salaries, not being management charges. And really, to put that beyond doubt, can I just take you to briefly to the Appellant's skeleton argument on the consequentials, because I just said that it actually laid out the basis upon which these were properly awarded by Mr Justice Leach, was formed a part of the argument, and in fact part of his decision when it came to the consequentials. So if I could just briefly take you to that, Your Lordship, it's tab 10 of the supplementary.
Yeah.
Where this the Appellant's begins at page 185, skeleton argument for the claimant, and he produces his own final figures for the account at page 186. So in a sense, a rival table, but this was the position being adopted by the Appellants on the consequentials hearing. The figures for the account following the supplementary judgment should be as follows. And you'll see that there's money to receive, occupation charge, so the figure for table income, less transfers by Christo to Docklock, then management fees, and that's 28,000, which was the subject of the supplemental judgment. Then the professional fees, which are gathered together, total 160,000, and then disbursements expressly authorised. And you'll see under that heading, staff salaries. And the point is rather confirmed, paragraph 9, page 188.
Yeah,
This
9
summary
Roman
follows.
2 deals with the salaries.
Yes. And I say there was an argument over getting too involved. There was an argument over a Part 36 offer that we had made, and whether that offer, which referred to management charges, included staff salaries. And Mr Justice Leach certainly took the view that the letter, when it referred to management charges, wasn't including the staff salaries, but he went further than that in his decision and said that they were never paid as management charges and they were not awarded as management charges. There it is. So it comes back perhaps to the narrow in lieu of management charges point.
Yeah.
And that means instead of so I say that there are proper disbursements made within the relevant period for those reasons. If I may just turn that. Those are my submissions.
Thank you. Mr Lightman, do you wish to reply?
Yes, please, my lord. I'll be very brief, but I'd like to make one or two points. First of all, by way of context in respect to the amount of the sitting balance, or the agreement as to the figure, what the position which Docklock adopted at trial was that, and told the judge, it was because there was no practical difference between the two figures, the outcome was the same, regardless whether Docklock's figures were used or Christo's figures were used. They were not going to waste time arguing for one over the other.
What was your figure?
148 odd thousand, the figure which was as per the Rees.
Oh, I see.
I just explain that for context, not as a sort of a sword or shield for the case, but just so. Although my defence has tried to turn that into some form of further basis of the defence to this appeal.
But
So-
if your figure for the sitting balance was based on the Rees, it would support the argument that the payments in respect of VAT had already been appropriated. On the other hand, if the calculation is as Mr Letman's schedule, that would support the argument that either it hadn't been, or if it had, it was being reversed. So, although there may not be much difference in the eventual totals, there is, at any rate, potentially quite a difference in their makeup.
Yes. Well, my lord, our argument was they were appropriated back
Yeah.
in October. I just wanted to explain why there wasn't a fight about that at the trial. Now, with respect...
Does that mean you accepted the figure of 134?
Yes, I think the judge records that. By the close of trial.
But by close trial it was accepted.
I think
It
Mr
was
Kaminsky accepted the 134,000.
Yes, my lord. Yes. I just want to say a little bit more about the issue of what the impact of the settlement of the order and the settlement agreement is. Now, if we go first of all to the judgment of Lord Justice Moylan, or Mr Justice Moylan, which is at core bundle, supplemental bundle divider 18. Paragraph 2 said this: the issue I'm determining now is whether there should be a specific exception in respect of an asserted claim which a company Docklock believes it might have against the husband's company Christo Co and or the husband personally in respect of monies received by Christo Co as agent for Docklock on the basis that there's not been a proper accounting of those monies, in particular of rent to Docklock. I'll emphasise that, proper accounting of those monies. Now, if one then goes to the order itself, which is at core bundle divider 16, paragraph 19. So it's at page 244 and 245. It says, furthermore, the parties agree that save in respect to potential claims listed in subparagraphs A, B and C below, etc., this order together with a mutual waiver agreement is intended to be in full and final satisfaction of all any claims in England and Wales and any other jurisdiction that the companies have against each other. And the exceptions on the next page include any claim or counterclaim by any of the companies, applicant companies against Christo Co, etc., in respect of any monies received by Christo Co in respect of the relevant period, for which it is asserted that Respondent and or Christo Co has not duly accounted to and or has not paid over to the company, including in respect of rent. And similarly, clause 2 of a WCIA, which is at page 26. So page 272 talks about any claim or counterclaim by any of Betty's companies against Christo Co, etc., for which it is asserted that Chris and or Christo Co has not duly accounted to that company in respect of rent, and including respect of rent. Well, what we say in respect of the first disbursements is that there has been a proper accounting by Christo in respect of those first disbursements. And that took place long before the Moylan order. The way you might test it is, if the Moylan order had not been entered into, if the WCA had not been entered into, would there be a claim which Docklock could bring in respect of the first distributions?
Well, you wouldn't be claiming in respect of the distributions, you'd be claiming in respect of unpaid rent.
Unpaid. But what we're saying, the issue is whether there should be seen to be a retrospective disturbance of an allocation, an appropriation that's already taken place. And what we say is that it's not the case that there was a claim that could and should have been carved out. If we go to paragraph 61 of the judgment, page 86, bundle 1, divided 9. What the judge says, the exception carved out in 2A extends only to any monies received by Christo as agent for any of Betty's companies in respect to a period beginning of 1st of October 2014. Page 86. This did not include any sums received before that date, but still held by Christo. If the parties had intended to preserve such a claim, they would have expressly done so in clause 2. That's what the judge said. What we say is that we are not seeking to bring a claim in respect of sums received before that date. We are saying that the appropriations which were carried out in respect of those monies within the relevant period, were not upset by or retrospectively changed in terms of their characterisation or their effect by the order or the WCIA. And when the judge says, oh, they could, parties could have, if they wanted to do a carve out, they should have done. Well, there wasn't any need to do so, and there was, so that is not the right lens to view the situation.
I think Mr Miskey is trying to draw your attention to something.
I don't know if it's pointed out to me, but there was, as at the date of the Moylan order, we didn't have a claim to the sitting balance. We'd already received it by means of the appropriations subsequently made, by means of the first distributions. Hence the word distributions. So that's what I had to say on the first ground. On the second ground, with respect to staff salaries, I want to say two things. One is the way the argument was put by Christo Co in the Scotch schedule, maybe worth considering. It's in supplemental bundle, divider 5, page 56.
The black column is you and the red column is Christo, is that right?
Yes, my lord. What we said in the middle column, this payment was taken in 2015.
Sorry, which page have you on?
So it's page 56, my lord.
Thanks.
Internal page 10. This payment was taken in 2015, regardless of any agreement between the claimant and defendant in relation to this payment. It is not a permitted claim under the MWA, and the claimant's primary position is it's been deducted without authority. And no, it's not permitted under the MWA. And the response, Christo Co in red, the challenge is unprincipled and denied, as acknowledged in the reasons this payment was the subject of agreement between C and D and duly authorised by NC on behalf of C in lieu of management fees. So that deals with this sort of authority authorisation bit. Further, notwithstanding the sum of 62,000 relates to the year ended 5/4/14, given that this balancing payment was only calculated and made in the relevant period, it is a legitimate deduction. In the premises, the said balancing payment is probably deducted pursuant to paragraph 19A of the Moylan Order and the equivalent provisions of paragraph 2 of the MWA. So the position adopted was it was a proper reduction under 19A, not there's no reliance placed on 19B in respect to that payment. It wasn't said to be something other than a management fee or in lieu of management fees, and you'll see in terms of the language, perhaps should have highlighted that.
Sorry, I haven't understood that. 19A is your claim for rent.
Yes, sorry, yes. Well, I think what I'm saying, Manu, is that they sort of, maybe I must put it the wrong way. If you look at 56, they've described it as being in lieu of management fees.
Yeah.
Yes, but they're not claiming it under 19B, which is a claim for management fees.
Yeah, they don't know.
They're claiming it as a deduction from rent
Yes.
under 19A, and that's exactly how Mr. Letman is still claiming.
That is how it is. Maybe I wanted to tell that, see show court how they did put it. What we say is that this it is effectively to be characterised as a management fee, and the fact that it may, in terms of its calculation, be based upon a salary, a notional salary, doesn't turn that somehow into something which permissibly can go back before the relevant period it's still against us on our primary case. I see. I should like to point out that the management fee permission would only be in respect of a management fee in that period. With it incurred in that period or in respect to that period. I just want to make one final point, which is my letter took your lordships to the skeleton argument for the consequential skeleton. Mm-hmm. Now, that was a consequential skeleton. That's a supplemental bundle divider 10, page 188, etc. And the context of, I'm not going to, it's a skeleton argument in respect of costs, etc., at a consequential hearing. There was a separation out of these claims for the purposes of that consequential hearing, because the question was whether what the consequences were of certain settlement offers that had been made.
Yeah.
And they, for example, would relate to management fees on a quantum merit basis, whereas this was put on the basis of an agreement to pay the salaries or pay management charges in lieu of management charges reflecting those salaries. To characterise, they don't provide a guide to how one should properly characterise the staff salaries element. One would have to look at the various cost offers made and how they were defined.
But what this skeleton argument is doing is encapsulating what the judge decided. It's not necessarily saying he's right to decide that. It's just saying this is what he decided. And in that respect, it's entirely accurate. That is what the judge decided.
Well, I'm not going to seek to persuade, to argue to the contrary. My point was, if one goes, let's say, to paragraph 24, page 194, the question is how one interprets a letter of the 14th of October 2020 and the wording used in that letter, and how, as at that date, by reference to the pleadings at that point, claims might have been, whether what would be covered by that in light of the later findings of the court. All I'm going to say about that, my lord, is it should be seen as in the context of settlement offers we haven't been looking at, and the exact words used in those settlement offers and what claims were intended to be covered by those in that correspondence, and hence addressed in that skeleton. I don't know if I can assist your lordships any further.
Thank you very much, Mr. Knight. Well, they're short points, but not entirely easy, so we will reserve our judgments. You will get a draft in the usual way. It comes with a fierce embargo, which means what it says, so it can be distributed only to those who are on the distribution list, which has already been given to the court. The receipt of the draft is your opportunity to correct our English, but not our reasoning, and we would hope that in the light of the draft you will be able to agree an order disposing of the appeal. If you can't agree an order, please make short submissions in writing, and we will make the order that we consider to be appropriate. The hand down, when it is ready, will be remote, and therefore there is no need for any further attendance. Thank you both very much.